Welcome. I'm Julie Thompson. Today we're having a COVID-19 forum organized by State Representative Josh Cutler, presented as a legal aid services forum. This forum will be a great opportunity to get legal expertise in some particularly relevant areas right now and learn about resources that are available to help you. You can watch this forum in our viewing area on our government and public channels or PAC TV's live streaming channel Prime, which you can view at pactv.org/live. You can also watch this on Josh Cutler's Facebook page. If you have any questions during the forum, please email them to questions@pactv.org. And for replay times, visit pactv.org/regional. Josh will introduce his special guest for the forum today. Welcome, Josh.
Great. Well, thanks, Julie, and thanks the whole crew at PAC TV. It's great to be back. We really want to thank you and all of your team for all the great work you're doing, allowing us to have these kinds of forums. We wouldn't be able to do that without you, and obviously, community access television, is an important part of this, and it's been really helpful during this pandemic. So thank you. So again, everybody, hi, I'm Josh Cutler, State Representative for the 6th Plymouth District, representing the towns of Pembroke, Duxbury, and Hanson. But today we have a great forum that's applicable to really anybody in the Commonwealth. We have some great experts in civil legal aid that are going to talk about common issues that people encounter during this pandemic, especially. So I want to introduce briefly, the format of the program is going to be, we're going to introduce each of our experts. Sue Nagle is going to talk a little bit about South Coast Legal Services. It's the company that manages all this great work for our region. And then we're going to take some questions. We have some questions already that have been submitted. And we're also going to take questions from our studio audience, or our virtual studio audience. So if you have a question, you can email it in josh.cutler@mahouse.gov, and we will try our best to get to all of your questions. As Julie said, this show is streaming live on PAC TV. It's also on my Facebook page, and we will be rebroadcasting it, and there will be a link to be able to watch this later on if you weren't able to catch us live. So with that, again, welcome everyone. Again, let's introduce our great panel. We're just so pleased that we have some legal experts here to talk with us. First, we have Susan Nagle, who is the Executive Director of South Coastal Counties Legal Services. We're going to hear from Susan in a minute. Laura Camara, who is a senior attorney at the Justice Center of Southeastern Massachusetts. Michelle Heap, who's a staff attorney at South Coastal Counties Legal Services. And Beth Goodfellow, who's a senior attorney at the Justice Center of Southeastern Massachusetts. So welcome all. Thank you. I'm now going to turn it over to Susan Nagle, who's the Executive Director, who's going to just give us a little bit more information about South Coastal and all the great services that they offer. So welcome, Susan. Take it away.
Good morning. Thank you so much for hosting us for this meeting, Representative Cutler. We really appreciate it, and for giving us the opportunity to talk with your constituents about the services that we can provide, especially during these challenging times. Shall we say, we hope that all of the members of your community and their wide circle of loved ones are well and adapting to all of the challenges that we've all been experiencing over the course of the last few weeks. As Representative Cutler said, my name is Susan. I'm the Executive Director of South Coastal Counties Legal Services, which includes a subsidiary which we created called the Justice Center of Southeast Massachusetts. Our organization provides free legal representation in critical civil legal matters to low-income and other vulnerable members of the community. We provide our services throughout all of Southeastern Massachusetts, Cape Cod and Islands. That includes the greater Brockton area, most of the South Shore, all of the South Coast, and Bristol, and Cape Cod and the islands. As I said, we provide services in civil matters. We do not provide representation in criminal legal matters. We have offices in Hyannis and Brockton, and those are the offices which serve the greater Brockton area and the South Shore. We also have offices in New Bedford and Fall River, which serve the Bristol County area. And while our offices are currently closed to the public, we are working. We're open for business. Our intake staff, those are the folks that take applications for new services from new callers who may be seeking help from our organization. Our intake staff is available to new applicants, I think a little bit later in the program, the number that you can call for help and or a way to submit a request online for services. That information will be provided to you so that if you believe you may be eligible for services, please don't hesitate to reach out to contact us. We provide services largely, we specialize in areas, legal areas that are most likely to have an impact on low-income families and or older residents of the community, people who are 60 or older.
Did we lose Susan? Or froze?
Yeah, she froze.
Consumer matters, education,
Okay.
domestic relation cases, especially where domestic violence is an issue. And we also have a special program for people who are 60 or older. And in this case, in the case of Rep. Cutler's constituents, it's funded by by OCPC out of Brockton, and Beth Goodfellow in particular is funded by that project. So that's kind of the overview of the organization. And again, if you think you're eligible and that you have a legal problem, please don't hesitate to contact us. We are not experts in every area of the law. As I said, we tend to focus. Our focus is on low income and vulnerable communities and the legal problems that they are most likely to experience.
Great. Well, thank you, Susan. We appreciate that great overview. I think we'll turn it over to Laura Camara to introduce herself. Laura, welcome.
Good morning. My name is Laura Camara. I'm a senior attorney at the Justice Center of Southeast Massachusetts, and my focus is in housing and benefits law. The one item that I would like to highlight before I get to questions that were submitted or your questions that you would like to submit is the eviction moratorium that was signed by Governor Baker on April 20th. This moratorium stops evictions and foreclosures at all stages, provided the eviction is a, quote, non-essential eviction. So a non-essential eviction includes evictions for non-payment of rent, for cause that is not a threat to health or safety, and for no cause, so where a landlord just wants their apartment back. When I say it stops the process at all stages, it bars a landlord from serving a tenant with a notice to quit, which is the first step in an eviction process. It bars a landlord from filing an eviction case. And in fact, the court has altered their filing process so that such cases are not able to be filed at this time. It stops any cases that have already been filed from proceeding. The court will not schedule any hearings and will not accept any filings in those cases for the duration of the moratorium. It also stops the court from issuing a judgment, meaning the conclusion of a case, or an execution, the legal document that is needed to actually move a tenant out. And finally, it stops sheriffs or constables from levying on an execution, meaning actually moving an individual out during the duration of the moratorium. The moratorium is set to be in effect until August 18th or 45 days after the governor lifts the state of emergency, whichever date is sooner. The governor does have the ability to extend it for 90-day periods, but as of right now, it will be in effect until August 18th. Essential evictions are permitted to go forward, and an essential eviction is an eviction where the landlord is alleging the tenant engaged in criminal activity or a lease violation that endangers the health or safety of the landlord, other residents, or those lawfully on the property. A landlord who believes that a tenant has engaged in that kind of behavior can proceed with sending a notice to quit, can proceed with filing an eviction case, and if they have a case that's currently pending and the tenant is continuing to engage in or again engages in behavior that endangers those lawfully on the property, the landlord can ask the court to proceed with the eviction. On the homeowner side, the eviction moratorium also protects homeowners from foreclosure. A mortgagor, a lender, is not allowed to proceed at any stage of a foreclosure during the duration of the moratorium. Additionally, it provides for a forbearance, meaning that homeowners who have a financial hardship related to COVID-19 may request a forbearance, a pause in their mortgage payments for 180 days. And for that period, no fees, penalties, or interest can be charged. This money is not forgiven, but under the moratorium, it will be added on to the end of the mortgage, and the homeowner will be able to pay it at that time. Additionally, the moratorium provides protections for tenants from being charged for late fees if they are unable to pay their rent due to COVID-19, and provided that within 30 days of missing a rent payment, they provide their landlord with verification that they have a financial hardship due to COVID-19. So this is a really important protection during this state of emergency. It's a matter that the governor signed because it truly is a public health protection, that we need our residents to have homes to stay in, to have homes to quarantine in, to shelter in place in, to remain safe, and to keep us all safe. So from that, I'm happy to answer questions that anyone has regarding the moratorium or regarding housing law more generally.
Great. That's great. Thank you, Laura. Appreciate that. And just to give a plug to my institution, the legislature did pass that law, so we're glad to see that. And I know we have a lot of questions about landlord-tenant and housing-related issues, so I know we're going to come back to you and talk more about that. I want to now introduce Michelle Heap, who is sort of our expert today on unemployment and benefits issues. Michelle, do you want to introduce yourself a little bit?
Sure. Hi, I'm Michelle Heap. I'm a staff attorney with South Coastal County's Legal Services, and I am based out of the Hyannis office out on the Cape. So obviously there have been a lot of changes with unemployment, with the COVID-19 quarantine. And in addition, the benefits aspect of my practice includes food stamp or SNAP eligibility, mass health eligibility, or terminations and appeals. Obviously, a great deal of these programs have been affected by legislation, relief packages on both the federal and state levels. So there is expanded unemployment available, expanded SNAP benefits available, and Mass Health has stopped terminations and kind of given presumptive eligibility to applicants. And SNAP is also available for families who are newly poor due to a loss of income because of COVID-19. So I'm happy to answer your questions on any of those programs, as well as with emergency assistance shelter.
Great. Well, thank you, Michelle. We appreciate that. I'm sure we'll be coming back with good questions. And last, certainly not least, we want to invite Beth Goodfellow, who's a senior attorney focused on the area of elder law. Beth, welcome.
Hi, my name's Beth Goodfellow. I work at the Justice Center in Brockton. I do exclusively work with people that are 60 and over. We get a grant from Old Colony Planning Council to provide free legal services to people over 60 that live in our service area, which covers Plymouth and the 23 towns in the greater Brockton area. And it's really a general practice for elders. There are no income or asset guidelines, unlike the assistance that we can provide to younger people. But we concentrate our efforts on elders in the greatest social and economic need. And I'm also happy to answer your questions.
Great. All right. Well, welcome, team. Again, thank you all so much for taking some time out to address our constituents' questions. I have a long list of questions already. I do want to invite folks who are watching this live. And again, we want to thank PAC TV. This is streaming live on PAC TV. It's also streaming live on my Facebook page for State Representative Josh Cutler, my Facebook page. If you have a question and would like to submit it, we'll do our very best to get to all the questions. You can email questions to me at josh.cutler@mahouse.gov. And my trusty aide, Cole, will be monitoring that and sending those to me. We're multitasking here. So, but the good news is we have a lot of questions already. And in fact, Laura brought up a question, an issue that someone had already asked a question about, and I wanted to come back to you, Laura, and clarify this, because I think you've already answered it, but let me just clarify. The question was, how do homeowners ensure that the bank servicing their mortgage complies with Mass General Law for the forbearance provision for 180 days added to the end of the loan and not payable when the forbearance ends? Does that make sense, Laura?
Absolutely. So what I would say is that if you have reason to believe that your bank is not complying, for example, if they send you a letter demanding payment at the end of the forbearance period, the best step to take at that point is to reach out to the Massachusetts Division of Banks. Massachusetts Division of Banks is tasked with overseeing financial service providers, which includes mortgage lenders in Massachusetts. And they do have a system where you can file a complaint and they can reach out to your lender and try and resolve the issue. In this case, advise the lender that they're not in compliance with the law. Another resource that would be great to reach out to in that situation is to the Massachusetts Attorney General's office, to their consumer division, to notify the Attorney General that the lender is not complying with the law.
So just to be clear for everyone listening or watching out there, if someone were to choose a forbearance, and let's say there was a 3-month period where they're having forbearance for their mortgage, those 3 months are payable at the end of the term, not immediately at the end of the forbearance.
Correct.
Right. So
and
that's
at
a big
no
difference.
point can you be charged interest for that amount.
Okay. I've seen a lot of sort of maybe misinformation on Facebook and elsewhere, and sometimes I'm surprised, unfortunately, that's payable. The forbearance is due right at the end of the forbearance, which is not correct, is what you're.
Correct. And where I think some of that misinformation may be coming from is some confusion with the Federal CARES Act. The Federal CARES Act also provided for a forbearance period of 180 days for homeowners with federally backed mortgages, which is approximately 70% of the mortgages out there.
Mm-hmm.
That forbearance did not, by law, tack on at the end. If you did choose that forbearance through the CARES Act, in that case, it could potentially be payable at the end of the forbearance period. So that may be where some of the misinformation is coming from. The Massachusetts law provides a greater protection than the federal law.
A resident or a homeowner, how do they actually choose which forbearance to pursue? I mean, it's somewhat confusing. Like, how do you do that?
So if they're a Massachusetts resident, it's not a matter of choosing.
Okay.
They are automatically, if they request a forbearance, it is pursuant to the Massachusetts law. And the forbearance period is the 180 days starting from the Massachusetts law period and is payable at the end. What I would add is if for some reason the Massachusetts period is not extended and the federal state of emergency continues, the Federal CARES Act does allow for an additional 6-month forbearance period. So if homeowners are in need of that additional assistance, they could pursue that after the Massachusetts period. They could request that additional 6 months from their lender. But that period, that 6-month period would be payable in accordance with the lender's terms, likely in an installment plan after the forbearance lifts.
Okay, great. Well, so if you're a Massachusetts resident, the good news is that we have a stronger law than the federal government, and so you're protected. And if you may have banks from out of state that may not be as familiar with this, and it is important to be a good consumer here and to advocate, as you said. So there was that information was gold, and we've already earned the price of admission. So thank you all for clarifying that, because I've gotten that question, and I appreciate it. A couple other, Laura, I'm going to pick on you a little bit more. Sorry, I have a few housing landlord-tenant type questions here. One is, do I still have to pay rent during the eviction moratorium, and can my landlord charge me a late fee if I don't?
So if you are able to pay rent, you absolutely need to continue to pay rent. The last thing we want is a rash of unnecessary evictions when this moratorium lifts. But if you are unable to pay your rent due to COVID-19 related issues, like you've lost your job, as many have, you cannot be charged a late fee as long as you provide your landlord with verification within 30 days that you were unable to pay due to a COVID-19 related hardship.
Some related questions here. So my landlord wants to show my apartment. Do I have to agree?
So at this point, there is no statewide law specifically barring this. Some cities and towns like Somerville and Boston have placed emergency orders saying that landlords cannot show apartments. What I would say, though, is if a tenant is concerned that a landlord wants to do this and they are concerned about their health and safety, and the landlord is insisting, this would be something that would be an emergency matter the housing court would hear. And I would tend to believe that the housing court would order the landlord not to show the apartment during this public health crisis.
Okay. My landlord changed my locks. What can I do? So
the housing court is open. It is not physically open to the public, but it is available for emergency matters such as lockouts. The best way to reach the court is by calling your local clerk's office. In this region, it would be the clerk's office in Fall River or New Bedford. Reaching out to that clerk's office and requesting to have an emergency hearing by phone to order your landlord rather to let you back into your apartment.
Okay. So I'm a tenant and I need repairs to my unit. What can I do?
And that would be the same answer if it's an emergency repair. So an emergency repair would be something like you have no power, you have water gushing in, potentially an infestation if it's truly rising to a health and safety level. In those cases, you can contact the housing court and request an emergency order that the landlord repair your unit. If it's not an emergency matter, if it's more of a minor maintenance issue, my recommendation that I'm making to my clients and to other tenants who contact me is that you may want to wait and have those issues addressed once the public health crisis lifts. The less people you have coming into your apartment, the better. Safer for you, safer for the other tenants.
Now, do you know if an oven or refrigerator, would that be considered essential or not?
I would consider that essential, and I think the court would as well, yes.
Okay, gotcha. From the landlord's point of view, once the moratorium lifts, can I evict my tenant if they have not paid their rent?
Once the moratorium lifts, landlords absolutely have the right to serve a notice to quit for non-payment of rent if the tenant has not paid during the moratorium period. Even if they can't charge late fees for that, they are allowed to seek that money through an eviction process. The tenant does have the right to cure under state law if they receive a notice to quit for non-payment, and it's the first time in the last 12 months. But if they do not cure during that period, during the 10-day cure period, the landlord may pursue an eviction in the housing court or in the district court and seek both repayment of that money as well as possession if that's what they choose to do.
Okay. And I have one more question here, and then we'll share the wealth a little. So I'm not able to pay my mortgage. Is there anywhere I can get help paying? Can I be evicted if I have COVID-19 or am showing symptoms?
So as to the first question, if a homeowner is unable to pay their mortgage, in addition to requesting the forbearance that's provided by state law and later by federal law that extends that long, they can potentially obtain assistance up to $4,000 with mortgage payments from the RAFT program, Residential Assistance for Families in Transition program. That's administered by NeighborWorks Housing Solutions in this area. Their office is in Kingston. You can contact them either online or by phone to apply for RAFT assistance. You do have to qualify based on your income, but anybody who's having trouble paying their mortgage, particularly if you've lost your job, should absolutely reach out to NeighborWorks Housing Solutions to apply for assistance.
So sorry, go ahead.
As to the second question, can you be evicted if you have COVID-19 or showing symptoms? So My initial response to that would be no. I believe it would be considered discriminatory for a landlord to evict a tenant purely because they are suffering from a health condition. That said, tenants should keep in mind that if they are ill with COVID, are showing symptoms, that they need to follow the CDC guidelines, and they do need to self-quarantine and do everything they can to prevent other tenants and the landlord's staff from becoming ill. I do think that if a tenant were blatantly not complying with those standards and were thereby endangering other tenants, a landlord could potentially have recourse to the court, but not simply because somebody is ill.
So a follow-up question. This might be a good segue to Michelle, because I'm not maybe her wheelhouse. But if for RAFT or for other benefit programs, let's say you had a steady income that would make you ineligible for those programs, but then you lose your job. Obviously, your new income would be would qualify you, but all your documentation, your tax returns, everything's going to show that you had an income. Can you still apply, and how do you document that to meet the income requirements to be eligible for these kinds of programs? And I don't know if that's Laura, you want to grab that, or Michelle, if you want to take that too.
Yeah, I can absolutely answer that. So the benefit programs look at your income at the present moment. And as you indicated, Josh, a problem is how do you document that? Well, most of these programs have relaxed documentation standards at this point in time because they understand that it's going to be difficult for people to obtain that third-party documentation. But one way that you can document it is if you have lost your job and you're receiving unemployment benefits, you can provide verification of those unemployment benefits by printing out your benefit statement from the DUA online system is one way. If you're applying for unemployment benefits, you can provide verification that you are currently applying. And so that is one way to document your income. Another way to document it would be through a self-affidavit. In most cases, if you've lost your job and for some reason are not eligible for unemployment, you can document it that way. Okay.
That's great information. So, and that is a good segue, because we want to turn to Michelle now. And Michelle is an expert on unemployment and benefits issues, which unfortunately are a big topic these days. I know our office gets a lot of inquiries about unemployment-related issues, trying to help folks. So we're glad to have Michelle and her expertise here. So Michelle, I have a few questions for you as well, if I may. Number one, how can someone who is not receiving unemployment due to an error in the application reach the Department of Unemployment?
So this has been an issue for a lot of people, and this was the UI online system had plenty of issues before we had millions of additional applicants. So there have been a lot of technical issues that really just need to be resolved by somebody within the DUA. And for the first several weeks of quarantine, people had a really hard time reaching anyone at the DUA. So their preference for some time, and I think this is still going on now, is that you fill out a contact request form, which is available on the DUA website. And now that the volume of calls that they've been receiving has decreased a bit, there is a phone number that some people have been able to get through to them, and that's 1-877-626-6800. Great.
Okay. And I just add, for folks, for these kinds of matters, it can be helpful to contact your local state representative. And if that's me, then feel free to reach out to our office as well. Before we continue, I just want to give a plug. We're here live with PAC TV doing a forum on civil legal aid. I want to thank PAC TV for hosting this. I want to thank our staff attorneys and senior attorneys from the South Coastal Legal Services and the Justice Center of Southeastern Mass for providing expertise. If you have a question you would like to see addressed on the show live, please email it to me. My trusty aide, Cole, will be reviewing those and forwarding them to me. The email address is josh.cutler@mahouse.gov. And with that, we'll go back to Michelle with another few questions here. So Michelle, should recipients of unemployment report the additional $600 per week as income for the purpose of subsidized housing?
So the supplemental unemployment should not be included in income for those purposes. It depends on the program, and there's a lot of variance, even outside of housing, like within for SNAP purposes, you should not be reporting that. And then within the emergency assistance shelter world, depending on the program that you are trying to get involved in, for example, it may affect your eligibility for home-based funding. If you're already in the EA shelter system, they do not count it. But if you're trying to get into the EA shelter system, then they will. And that will affect your eligibility for those programs. So for subsidized housing, you should not be reporting the stimulus check or the supplemental income. But for other programs and benefits, you should check because they are all using that information differently.
Okay. Related question about unemployment, and I guess this would apply for DUA and also PUA, meaning the traditional unemployment and also the pandemic unemployment. Do I still need to complete the work search requirements?
So if you were on regular unemployment before the pandemic hit, the DUA advises you to work search as much as you reasonably can, but they have lifted those stringent requirements in this time because it's nearly impossible to search for a job when places aren't hiring or aren't open. For pandemic unemployment, you do not have to complete the work search requirements.
Okay. Here's the question I've gotten a few times. Can my employer force me to use my own sick time before taking advantage of any paid leave assistance?
So the short answer to that is yes, they can. I mean, it depends also if you have a union contract where they're obligated to, that where the terms are explicitly different from that. But if this question is also related to the paid leave that was created under some of the pandemic relief programs, that paid leave has essentially just created an additional category for FMLA leave, but which would also be paid under the program. So whether or not you took FMLA leave within the last year would affect your eligibility for that as well. And it is also just something to consider if you're planning on taking FMLA in the near future.
And would this apply too to the Families First Coronavirus? I may be misstating the name of it. The new federal benefit that Congress passed. Is that?
Yes, the FFCRA. Yes, that was the program that I was referring to.
Okay, got it. Okay. All right, great. Well, thank you. I'm sure we'll come back to you with some more questions, but thank you for that. I want to turn to Beth for a moment, who is an expert in elder law. And Beth, I wanted to ask you, what can a family member of seniors living in a nursing home do if they can't contact the elder?
Well, I think first off, they could try the nurses station on the floor where the elder lives. And if they can't get in touch with anyone, because obviously the nurses are busy, they could try contacting the ombudsperson or the Ombudsman Program. The local number for our service area to reach the Ombudsman Program, if they never have before, is to call Old Colony Planning Council. And their phone number is 508-583-1833. There's also an 800 number if they can't reach anyone at Old Colony Planning Council. That would be more of a statewide number. That is 800-243-4636. The Ombudsman Program are people that try to work out problems for elders living in nursing homes, or if families have concerns, they'll try to work with the family and the elder and the nursing home to resolve issues. So that might be a good place to start if you have concerns about your family member living in a nursing home.
Okay. Related question, can legal documents still be executed during this state of emergency, and how?
The governor signed a remote notarization law on 4/27, on April 27th this year, allowing for people to notaries to remotely notarize documents for people. The law is only valid during the state of emergency due to the pandemic, and I believe 3 days after the state of emergency ends, the law is revoked automatically. So there are a lot of technical things that you'd have to follow in order to do this, but you need to be able to have a live video conference and the ability to record it and to maintain that recording for 10 years in order to take advantage of this. And everyone who is signing the document would have to have a copy. So the principal signing the document, the witnesses would all need to have a copy and be signing it on the live conference. And then the notary would have to get all of the documents, compile them, and file an affidavit in order for the document to become effective.
Okay, great. Another question, for Social Security and SSI recipients and their stimulus checks, what if they have a representative payee who is responsible for managing the additional money?
So the representative payee is specifically given the responsibility of managing Social Security and SSI benefits. So the stimulus check is not either of those. And so I think that the recipient of the Social Security or SSI would be able to manage that themselves. They certainly can ask for help from the representative payee, and the representative payee is allowed to help them. But if they want to manage the money on their own, they're allowed to do that.
Okay. And this question, Beth, I don't know if it's for you or maybe Michelle or anyone can grab it, but my employer asked me to come back to work. Currently, I'm making more money on unemployment. Do I have to go back if I don't think it is safe for me to do so?
So I think the answer to that is that it would probably be on a case-by-case basis. Regular unemployment law, prior to the pandemic, allows people to quit jobs if they have urgent and compelling reasons. Or good cause attributable to the employer. So in that case, you certainly can't say, I'm going to stay out of my job because I'm making more money on unemployment. But if they have valid concerns about their safety, then they could refuse to go back. And then I believe that it would be up to unemployment to determine whether or not they had good cause for doing that. And if unemployment found them not eligible, they are entitled to appeal that and have a hearing on the matter.
Okay, great. So I've gotten, so those are sort of my questions we got ahead of time. I've gotten a lot of questions in addition to that wanted to try to get to as many of them as we can. Again, you're watching live. If you do have a legal question for our experts here, we'll try our best to get to it. You can email in at josh.cutler@mahouse.gov. And Trustee Lieutenant Cole is monitoring that email and sending us the questions. So I got a few here, and I'm just going to kind of throw it out there, and I'll let whoever thinks they're best equipped to answer it jump in. Does that sound all right? So one question, here it is. I already paid for college class this summer, and now it's being offered online only. Can I get my money back, or do I have any rights to request a reduced fee? Who wants to jump on that?
I'll field this one, though Beth may want to because she has a college-age child. So the practical answer to this question is that you need to reach out to the school and make a request. The best thing we can all be doing right now is talking to each other and trying to resolve things. There are movements across the country right now trying to address this issue. Students are filing petitions. If your student wants to come together with their peers, filing a petition asking the school for reimbursement is a powerful tool. Additionally, the CARES Act, the Federal CARES Act, did provide funding to higher education institutions to provide emergency financial aid grants to students whose lives have been disrupted by COVID. And this can include tuition reductions and reimbursements. So there may be a pot of money available to assist you, which is why I say reach out to the school. But as far as from a legal standpoint, technically speaking, this is basically a contract claim. Are you being provided the service that you paid for? And in fact, there are suits currently pending across the country based on a breach of contract and unfair business practice on this very issue. So in theory, you could file a breach of contract claim if the school refuses to refund you, but that likely is going to result in protracted litigation. So I think your best bet is to reach out to the school and try and resolve it by speaking with the school about your financial hardship if you have one and your reasoning for wanting a reimbursement.
Great, thank you. We have here's another question. We have a small business and my husband pays $1,800 a month for healthcare. What will happen if we don't pay our monthly healthcare? We don't meet the requirements to be considered, quote, low income. Not sure what the answer to that would be, but anyone want to try to?
I'm also happy to field that one.
Sure.
So under the ACA, the federal law, also known as Obamacare, recently the federal tax penalty that was in place for if you did not have health insurance was reduced to zero. So if you did choose to cancel your health insurance, you would face no federal tax penalty. Additionally, on the federal side, the CARES Act did include some money for small businesses in the forms of grants and loan forgiveness that can be used to cover expenses like payroll and rent and utilities during the crisis. So if you were able to apply for some of those programs, that might free up money to assist you in paying for your health insurance. On the state side, however, the Massachusetts healthcare reform law requires anyone over 18 to have health insurance for the entire year. A failure to have coverage results in a tax penalty, and the tax penalty add up for every month that you don't have coverage. There is a grace period that allows a lapse in coverage for 3 or fewer consecutive months. So potentially, if you did not have coverage for 3 months, you might not suffer a tax penalty. The other issue that I would raise, though, is that your healthcare premiums are tax deductible. So if you're self-employed, so you could reduce your taxable income by paying those health insurance premium costs. So it may not be in your best financial interest to stop paying your health insurance. Finally, talk to your healthcare provider. I would say your health insurance provider. They may offer a grace period, though likely you would need to repay those premiums at the end of the grace period in order to resume coverage.
Okay. All right, I got a question. This is probably for Michelle. So we got a few questions from realtors asking about specific aspects of unemployment. So I have sort of a two-part question here. I'll try to do it in parts. For a real estate agent or a commission-based salesperson, there's often a lengthy delay between when a commission is earned and when it is received. So when applying for PUA, Pandemic Unemployment Assistance, how should they report their income and how should they account for their expenses? That's the first part. Michelle, you want to try to address that again?
So if you are receiving what would be your wages, in this case, the commission, you do need to report that. It would only affect your unemployment benefits for that week. It would not affect whether you could continue to certify. You wouldn't be able to continue to certify that you are unemployed for the preceding weeks. As far as expenses, that I don't believe that that's part of what you need to report at this time.
Well, in other words, so if let's say let's say you're a real estate agent and you got a commission on selling a house, and it's a big lump of some money, that's before any expenses for, your fees for selling the house. You obviously, that would change dramatically your unemployment if you were to report that on a gross or net basis. So I guess the question is, how do you account for those expenses that you pay throughout the year that aren't coming out of your commission payment directly? That makes any
So
sense.
I think I would need to be a little bit more knowledgeable about how that works to be able to answer that any further. But any wages that you're receiving do need to be reported, but it should only affect your unemployment for the week that you've received it.
Okay, well, so follow up. Maybe this will make it easier or maybe more complicated. When asked, so if someone is on unemployment, when asked if they received any income when completing their weekly unemployment check-in, are they required to report a payment that was just received, even though it was for a transaction 2 months ago?
Yes, you do need to report that. If you don't, you would potentially be subjecting yourself to an overpayment, which would then have to be appealed at a later time. And it's particularly important to protect yourself from that if you're receiving the pandemic unemployment, because if you receive an overpayment for regular unemployment, you, depending on the circumstances, if it wasn't due to fraud, you have the option of submitting a waiver request. But the pandemic unemployment cannot be waived if you receive an overpayment for that.
Okay, so it sounds like, so if you have pandemic, if PUA related sort of detailed questions like that, what is the best advice you can give folks? Can they reach out to you, or what is the best advice you can give folks to kind of try to resolve those specific kind of thorny issues?
I mean, I think that contacting the DUA directly.
Oh, sorry, Susan.
You go ahead, Susan.
I didn't want to. Susan, jump in.
I think that, there are a couple of principles, and I think one principle that I think we can say applies to all benefits programs would be that err on the side of transparency in terms of, I think, reporting income or payments, regardless of what kind of public benefits program you may be involved in, or if you're applying for unemployment. And then the rules are thorny about what applies, or what's going to be included for this purpose, what's going to be included for another purpose, what's going to be excluded for purposes of another benefit. And I think those can be resolved. I think Michelle was going to say, I think you can contact the provider to try to help resolve some of those thorny issues. Or yes, we're absolutely available to try and help people think through their questions that they have about applying for a lot of these different public benefits and or unemployment compensation. And we can provide that number where people can access us at the end here.
Great.
Later, if we have time, I'd also like to say a few more words about the Families First Coronavirus Response Act and the leave that's available under that act.
Okay, great. Yeah, let me try to run through a few of these questions and then
Yes.
happy to do that. And we don't have a ton of time left, but we'll get through it. Here's one. So I work for a nonprofit. If a person works in a group home where there's a client with a positive test, that employee is required to stay home and not pick up other shifts at other homes. And unless sick, is only able to use their vacation or personal time. The employee is not allowed to use sick time unless they pick up the new 24-hour shifts if she has no symptoms. Is that legal? I'm not sure if that was totally clear, but does anyone have any thoughts about that one?
Well, I think
Go ahead.
I would
Laura.
just generally say that it sounds like, from what I'm hearing, that person potentially would be eligible for the leave that was provided under the federal law, which is an expansion of Family Medical Leave Act, the Family Medical Leave Act, provided that business is a business covered by the Family Medical Leave Act.
So this is a related question. Maybe it sounds fairly similar. Maybe it's the same answer, but I work at an essential business. A fellow employee may have had COVID contact and was tested. We are still waiting for the results. The employee is still coming into work and our employer has not done anything. I am concerned for my own family, for myself and my family's health. What should I do?
I'm happy
That's a
to
tough
try
one.
and tackle
Go ahead.
this one also.
Yeah, Laura.
Well, so, I mean, I think what I would say is there's not a clear legal requirement there for the employer to mandate that employee stay home. If you are in a union and you have, a union steward, you certainly want to reach out to them because that may be a workplace health and safety issue that may be covered by your union contract. So that's one option. Another option, if you truly feel unsafe, you potentially could leave your employment and be eligible for unemployment. Obviously, that's not someone's first choice, but under the current, unemployment expansion and how liberally the Department of Unemployment Assistance is interpreting the law at this time, you likely could be eligible for unemployment in that scenario if you truly felt unsafe, had a reasonable fear of contracting COVID at work, and chose to leave your employment. And then, finally, I would say another option is the Massachusetts Attorney General's office is very open to hearing from people about concerns. And so you always can reach out to them. They do have an employment division, and you could always reach out and let them know about your concerns. But no, there is not a legal mandate at this time for the employer to force that employee to stay home.
All right, I have a couple landlord-tenant related questions, so I think we'll go back to you, Laura. Sort of related. In terms of the eviction moratorium, are Section 8 tenants protected if they have an unauthorized person living in the apartment? And the second related question is, what recourse do tenants have if the landlord is engaging in unsafe behavior? So, So regarding the first question, so that is a question that actually has come up quite a bit. And what I would say is that my interpretation of the law would be that generally having an unauthorized occupant is not a lease violation that endangers health and safety. And so that would not be an essential eviction allowed to go forward under the moratorium. Okay.
That said, if that tenant or occupant is engaging in behavior that endangers other tenants, others lawfully on the property, then that potentially could be an essential eviction that could proceed even with the moratorium in effect. To answer the reverse side, the question you asked regarding whether if a landlord's engaging in unsafe practices, then that would be an emergency matter that you could access the housing court by phone and file a complaint for a temporary restraining order to bar the landlord from engaging in whatever behavior they were committing that was endangering you or other tenants.
Okay. An employment-related question here. I have a question regarding unemployment benefits once everybody starts going back to work. I have underlying health conditions, and I have a letter from my doctor stating that I should not go back until the second round of state are opening up. I work in the dental field. One of the doctors I work for is hoping to open his office on May 18th. I was wondering how this would affect my unemployment.
So there are a couple of things to think about as well, is whether their office is going to open back to full capacity immediately beginning on the 18th. Because I know that I've spoken to a number of prospective clients who have a similar issue, but they are either like they're only bringing a few people back, so they are able to elect to be one of the few who aren't coming back just yet. But if you have serious health concerns and your employer is, I think we kind of spoke about this already, that if you really can't return to work, you should be able to continue receiving unemployment because you can't return to work. You're not able.
Okay. I don't know if anyone can answer this. What is a reasonable legal fee for a basic will with a revocable trust? That was asked. I don't know if anyone does that kind of law. I would suggest, I can answer that if no one else wants to. I think that would be probably in the range of, between $500 and $1,500 for a will for most attorneys around here, I think. Perhaps others have different fee ranges. So this is maybe already asked and answered. Let me just throw it out there again. What should I do regarding unemployment if my employer asks me back to work, but I have an underlying medical condition? I don't know, we kind of addressed that already. Michelle, do you want to?
Yeah, I mean, the first thing to do would just be to communicate that to the employer. that you shouldn't be returning to work because you are one of the vulnerable population, and see if you're able to work something out with them. That would be the first step. If they are still trying to compel you to return to work and it's unsafe, I always recommend contacting the Attorney General's office with those kinds of issues as well.
Okay. All right, so we're caught up on questions. So while we have a little bit of time left, I wanted to turn it back to Sue. She wanted to perhaps talk about FRCA or related legislation. Sue, you wanna?
Yeah, however that's pronounced.
FRCA, I use FRCA, but whatever.
I can roll with that. I just wanted to clarify a couple of things that we've had a couple of references to the Families First Coronavirus Response Act and the leave that is available under that act. Most employers under 500 and with 500 employees or fewer have to provide leave that is available under the act. Employers with 50 or fewer employees can seek exemptions for part of the leave. So, but basically, employers have to provide 2 weeks of paid emergency sick leave for a variety of reasons. And that can include that you are sick yourself with COVID-19, that you have been ordered quarantined by a doctor because of exposure to someone with COVID-19, that you are caring for someone who is sick or quarantined, that you have a note from a doctor that you are experiencing symptoms that are one of the illnesses identified by the CDC that is like COVID, but you haven't tested positive. And then finally, because you have children. You can't work because you have children, and that includes teleworking, who you must care for, you must care for because the schools are closed or because the daycares are closed. And so it's important to be aware that you may have access to up to 2 weeks leave for sick leave and up to 12 weeks for expanded family medical leave under the Act to care for children because the schools are closed. Some employers allow you to use that leave intermittently, so you can put in a few hours a week and then care for your children a few hours a week as well.
So that's great. So I got one final question we're going to try to squeeze in, and then we'll do a wrap up. This is a consumer protection type issue, I think. So some retailers are unable to accept returns. I was told I can't return or exchange clothing at this time, and they're unsure what the return policy will be once they were able to accept returns. So it raises the question of, what are consumer rights if they were to have purchased something, tried to return it, but not able to because the store was closed, and then the time period by the time the store is open has ended. Will they still have the right to return items? Anyone have any thoughts about that?
Call the Attorney General. They have a consumer division. I'm laughing, but seriously, if you do have a consumer question like that, you can call the Attorney General, and they sometimes are able to resolve things like that. This is obviously an extreme, unprecedented time, and so there are going to be a lot of questions like this that, frankly, there's not a straight answer to right now on many fronts. And so I think what we are emphasizing, what most lawyers are emphasizing, is reasonableness. Let's all try and be reasonable. Let's all try and communicate and see if we can resolve these things amicably, because we're all in this brand new world that we need to figure out together.
Okay. So we're just about out of time. I want to thank everybody for participating. This has been great. I think we've covered a lot of material and a lot of good stuff. This is really good resources. I want to again thank Laura Camara from Justice Center of Southeastern Mass, Michelle Heap from South Coastal County's Legal Services, Beth Goodfellow from the Justice Center. And I want to just give Sue a quick chance. You got about 2 minutes, Sue, tops, to give a final pitch for South Coastal County Legal Services and where people can reach you guys. Susan?
Happy to do that. Thanks so much for that opportunity. And thanks again for hosting us and to PAC TV. We appreciate it. So if someone needs our services or believes they're eligible or wants to apply for services, please call us at 1-800-878-8255. 244-9023. And that will put you in touch with our intake team. You can also access us by sending us what's called an online inquiry. And in order to do that, you can go to our website at sccls.org, South Coastal Counties Legal Services.org, sccls.org. There, you will find a form there where you can submit some basic information about the help you're seeking or the question that you have, and someone will get back to you in a few days. Do not use that if you have an emergency of some kind. Please call our intake center Monday through Thursday, 9 to 2.
Great.
800-244-9023.
Got it. Again, thank you all. We appreciate it very much. Thanks for watching. We'll be replaying this show and it'll be available on PAC TV to watch. And hopefully we can do this again sometime. I want to turn it back now to our great host, Julie Thompson, back in the studio. And again, thank you all for tuning in. So Julie, take it away.
Thank you, Josh, and thank you so much, guests. This was really a tremendous amount of information. Josh, just a quick question. Will all of this that has been, all the resources, names, phone numbers, and everything, where will that be available? On your website?
Yes, Julie, we'll put that all on our website, joshcutler.com, or on my Facebook page. And obviously, and you can watch it again on PAC TV as well.
Great,
Yeah.
thank you. Yes, for replays, do go to pactv.org/regional, and it'll bring it up to all these regional forums that we're having. Josh has had a few before, and I'm sure we'll have some more. Great information. Thank you so much, ladies, for all your intel today. It was really, it's amazing how much is out there to help people if you just know where to go. So thank you, and thank you, Josh, for organizing this. Again, this was filmed this date. We date stamp everything because obviously things change on a daily basis. So make sure you're getting the most up-to-date information. Thanks again. This is Julie Thompson from PAC TV. Have a good day.